Hello everyone, I'm George from Ireland. So I'd like to talk to you about the sources of law in English law, just trying to block out that light that's maybe blinding you. So to review, there are statutes, which are laws made by legislatures. There are laws which emerge through court rulings. The statutes would include, incidentally, European Union law, and there's the European Convention on Human Rights, which of course by the Human Rights Act has been incorporated into UK law. So going back to statutes, the main one, the main source of these is Westminster, the Parliament of the whole United Kingdom. Now, some Westminster statutes apply to the whole UK, some only to England, and so on. So there's obviously the Westminster's bicameral, that's to say it's got two chambers, the House of Lords and the House of Commons. So if people propose a law, then there's a draft of it, it's called a bill, and if it's passed it becomes an act. So there's a green paper first of all, since 1967, which is the first proposal, and then there's comment on that, that'll be redrafted into a white paper, which is the government's clear proposal to go forward, and so on. We're not going to go through the legislative process, but the last stage, if it's passed, is the royal assent. They announce in the Commons, La Reine le veut, as in the Queen wants it. So she signs it into law. She's always signed everything. Every monarch signed every bill for over 300 years into law. So there's a difference in primary and secondary legislation. So primary legislation are acts passed by legislatures, whereas secondary legislation allows various government ministers to create statutory instruments, as in ministers can create regulations, orders, and so on. So sort of empowering them to make law. Okay, there's devolved legislation, which I hinted at, which is made by the Northern Ireland Assembly, Scottish Parliament, and so on, and obviously only affects their area of the UK. So the courts and the judges make law. Well, that's a little bit contentious. Some people think the judges shouldn't make law, that parliaments make it, and judges should interpret it. So Sir William Blackstone, in his commentaries of the laws of England, which he wrote in the 1760s, said this about how law is made by courts. The common law is to be found in the records of our several courts of justice, in books of reports and judicial decisions, and in treatises of learned sages of the profession, prescribed and handed down to us from times of ancient antiquity. They are the laws which gave rise and origin to the collection of maxims and customs which are known by the name of common law. Close quotation. Okay, so European Union law and the European Economic Community was founded in 1957. It became the European Union later on. In 1993, the UK joined the EEC in 1973. Anyway, so laws passed by the European Parliament were part of it. Obviously, regulations of the EU were part of it. Directives of the EU required national legislatures to reach a certain standard before a deadline. And EU matters were adjudicated before the Court of Justice of the European Union, which is Luxembourg. But the Court of Justice of the European Union is sometimes called the European Court of Justice, as an ECJ. So a leading case on European law was R against the Secretary of State of Transport, ex parte facto Tame number 2. That's a 1991 case about the Merchant Shipping Act. So that was passed in 1988, the Merchant Shipping Act, and so you could only fish in British waters if your crew was mostly British. Spanish fishermen said they missed out. Anyway, the long and the short of it is it was decided that the EU law definitely trumped British law. So Sir Edward Heath, the Prime Minister, had led the UK into the European Union, or EEC rather, saying that it would involve no essential loss of national sovereignty. The operative there was essential. And it was the civil servants told them, no, that's not true. And I can't remember which lord it was. I think it was Lord Denning, that judge in the 70s, said, no, this is a sort of incoming tide, flood up all our rivers of law, as it were. That might be a splendiferous thing, but let's at least be honest about it. It does change British law. It does prevail over British law when the two collide. So we know that now that the UK is outside the EU, all EU law remains on the statute books unless it's repealed. Okay, so the European Convention on Human Rights, ECHR, well, exists now, but I mean, human rights go back a long time, I suppose. Some sort of right to a fair trial, even in the early Middle Ages. But Magna Carta, meaning the Great Charter, was signed by King John in June 1215 at Runnymede, this meadow near Windsor Castle. You can see my channel, George from Ireland, where I talked about it extensively, and said that to no one shall we delay, deny, or sell justice, and so forth, and you mustn't fine a man to his utter ruin, setting out certain rules, but much of what's contained in Magna Carta deal with issues which are pertinent only within an exceptionally narrow geographical compass about the right to trade on navigable rivers and so forth. Okay, so human rights cases come up all the time, such as R against Charles the Exchequer, ex parte Witham, 1998. So this was the one about the Lord Chancellor saying no, low-income people are not going to be exempt from fees to access the courts. And the Lord Chancellor had acted ultra vires, so judicial review found against him. He'd gone beyond his powers. Anyway, so it was the Lord Chief Justice, who had the wonderful surname for a judge, Laws, who ruled on this case. And he said that the access to the courts was a constitutional right, and that couldn't be derogated from except by the wish of Parliament. The Lord Chancellor couldn't do that. Well, here's what Lord Laws said in this judgment. It seems to me, from all the authorities to which I've referred, that the common law has given special weight to a citizen's right of access to the courts. It has been described as a constitutional right, though sometimes cases do not explain what that means. In this whole argument, nothing to my mind has been shown to displace the proposition that the executive in law cannot abrogate the right of access to justice unless it is specifically so permitted by Parliament, and that is the meaning of constitutional rights. Okay, so the European Court of Rights, European Convention on Human Rights was drafted in 1950 and took effect in 1953. So countries which are part of the Council of Europe, they signed it. Now the Council of Europe is not the European Union. The Council of Europe is virtually all European countries from Iceland to Russia. One of the very few that's not part of it is Belarus. Turkey is part of the Council of Europe. So it's true that all EU countries are part of the Council of Europe, but half of the Council of Europe countries are not in the European Union. So the European Court of Human Rights meets at Strasbourg, and it adjudicates matters concerning the European Convention on Human Rights. Confusingly, the European Parliament is also based in Strasbourg. So the European Court of Human Rights is not the European Court of Justice, though they're often mixed up. So 47 countries are signatories there too. But it didn't stop the British Armed Forces committing many war crimes in Kenya. It didn't stop the French army committing numerous large-scale atrocities in Algeria in the 1950s, just after it was passed. It didn't stop the Soviet Union being horrifically oppressive and holding political prisoners, and there are millions at this time, and denying people fair trials as an absolutely standard thing, executing people on a huge scale and so forth, torturing on an industrial scale. So not really worth the paper it's written on, but there we go. It contains some noble sentiments. Much of it wasn't novel in the United Kingdom and had been part of British law for centuries prior to that. But anyway, it was a desire not to go back to the barbarism of the Third Reich that this was passed. So the European Convention on Human Rights said that people could have their day in court in Strasbourg, but only when all domestic remedies have been used up. Anyway, so what are the rights and freedoms that you find in the European Convention on Human Rights? Well, it's got a number of articles. So the convention, as we often call it, has articles 2 to 14, which are articles which enshrine rights. Okay, some of the protocols are about procedure, but Article 2's got the right to life. Article 3 forbids torture under all circumstances, and you can't say there's a crisis or a terrorist threat. Doesn't matter, cannot torture. Article 4, it outlaws slavery or forced labour, but it says, but compulsory military service is acceptable in an emergency situation, saying obliging people to, say, build flood defences, that would be acceptable. But generally speaking, forced labour is not permitted. Article 5 says the right to liberties and security. Well, we can't actually guarantee people will never come to harm, but anyway. Article 6 ensures you have a right to a fair trial. Article 7 says, well, null crimen sine lege. Article 8 says you have a right to family life and privacy. Now, does that include gay family life? These days, it does in many Western European countries. Article 9 says the right to freedom of thought, conscience, and religion. So, but wait a second, you're prohibited if you're a member of certain organisations from doing certain jobs in the UK, being a prison officer, a teacher, a police officer. So you see how it's a nonsense, this convention. Your rights are taken away from you. Article 10, there's freedom of expression, but you're not really. I mean, you can still go to jail for incitement to racial hatred or religious hatred. You might say that's a good thing, but let's not say that freedom of expression is that important. You might say we have freedom to some expression of certain opinions. Article 11, freedom of assembly and association. Freedom of association is to found your own club or to socialise with those whom you wish to socialise. Article 14 says no gender, no racial discrimination and so forth. Article 1 says no death penalty. Wasn't there in the beginning, but it is now. Article 3 says free elections, fair elections, no cheating. Votes for all adults with certain exemptions for the mentally ill people in prison and stuff. So there are derogations. Now you could derogate from some of them. For example, the death penalty. It has to be a crisis so bad it's threatening the life of the nation. Torture you cannot derogate from, no matter how bad it is, even in a world war. So there is a margin of appreciation, saying that in different states you can do things a little bit differently. For example, there was Lautsi against Italy in 2011. So here an Italian citizen said it's wrong. There's a crucifix on the wall of the classroom where my children are taught, because that is sort of taking away our freedom of conscience, and it's promoting one faith over the others. But anyway, the court said no, that's acceptable. That sort of Italian culture. It might not have been acceptable in another member state. So the European Court of Justice and European Courts of Human Rights, they also look at proportionality. So do English courts. Things have got to be proportional. So you have to achieve a certain objective, not go further than what you need to do to achieve that objective. Lord Justice Laws talked about proportionality in 2013. He said it's all about minimal interference. This is what Laws said. Every intrusion by the state upon the freedom of the individual stands in need of justification. Accordingly, any interference which is greater than required for the state's proper purpose cannot be justified. This is the core of proportionality. It articulates the discipline which proportionality imposes on decision makers. So there was an important case of De Freitas against Permanent Secretary of Ministry of Agriculture, Fisheries, Lands and Housing in 1999. So Lord Clyde, he set out the criteria that courts should examine when they are trying to decide if legislation is interfering with someone's rights too much. He said, is the legislative objective important enough to warrant limiting your freedoms? And second of all, are the measures there intended to meet this legislative objective connected with that properly? And lastly, does the means used to limit your right of freedom do so in a proportionate manner? Okay, so let's see how the Human Rights Act works. It took effect on the 2nd of October 2000 in the UK. So when the UK courts, they can adjudicate on matters pertaining to the convention. So the convention rights are core. Canada, they've got something similar, the Canadian Charter of Rights and Freedoms.